Hi, this is Todd Jansen, and welcome to another 10-minute webcast. Today we're going to talk about ag data ownership. This seems to be a very popular subject, and so we want to start by asking the question, do farmers really own their data? So we hear this a lot in the media and with respect to companies that are working in the ag data space. And so I thought it'd be good to drill down and figure out what is it really about ownership that would apply here. And is it really fair to say that farmers own the data that they generate by their tractors, by their livestock, by the other Internet of Things types devices that they have on their farms? So let's start by talking about what exactly we're talking about when we mean ag data. So on the screen you can see a number of different types of ag data. I like to try and put them in categories because I think when you're talking about ownership, it matters what type of data you're really thinking about. So these are the different categories that the Ag Data Transparency Evaluator process uses, and Ag Gateway is another organization that likes to categorize data into different groups. And so this is really what we're talking about when we talk about ag data. I'm not going to go through them in detail, but I encourage you to look at aggateway.org for a more detailed explanation on what constitutes ag data. So when you're asking whether or not a farmer really owns the data they generate on their farm, the first thing to ask is, what exactly is ownership? Well, in the United States, ownership is a common law right that is also recognized by a number of statutes. And so in the United States, we have what is often referred to as a bundle of rights with respect to ownership. And this means that to own something, you have the right to possess it, to use it, to enjoy it, to exclude others from using, to transfer it to someone else, to consume it, or even to destroy it. And so when you think about the types of property that we recognize in the United States, this makes sense, right? Real property, you can transfer to someone else. You can generally do what you want with it. You can exclude others from it, and so on. Personal property is similar, something like a car. You can possess, use, enjoy, or transfer to someone else. Intellectual property is another one which is a little bit more unique in that intellectual property doesn't exist as a person, place, or thing or land. Instead, it is an idea or a concept. And so when we're talking about owning ag data, it really has to be a form of intellectual property for ownership to exist. So in the United States, we do recognize intellectual property ownership, but only in a few instances. One of these would be a patent, right? So a patent is an invention, something that's new, useful, and non-obvious. And I like to think that the Segway scooter is a commonly thought of invention, something that when it came along was not generally known, and no one else had really thought of it, and it had some utility as well. Ag data is not a Segway scooter. That doesn't really fit. Trademark would be another one, a symbol or a word or a name that identifies goods or services. Ag data isn't really that either. Copyright. This is another one that probably deserves a little bit more attention. So a copyright is a creative work fixed in a tangible medium, and it can be either a novel or a sound recording or a movie or video, but it usually requires some form of creativity and originality. And so this is where I think ag data doesn't really fit. It's not really something that could be easily copyrighted. There's nothing inherently creative about the way that a combine generates a yield data that ultimately is represented in a yield map on a field. So that doesn't really fit either. And that leaves us with the law of trade secrets. And I think this is probably the best fit in U.S. law for how you might say that a farmer owns the data that they generate on their farms. So the best example of a trade secret is the formula for Coca-Cola, which the company keeps under lock and key and doesn't allow others to have. Under the Uniform Trade Secret Act, which has been adopted by most states, this is the definition of a trade secret. And I won't read it to you, but I will highlight some of the aspects of it that are relevant to ag data. So a trade secret is information that derives economic value from not being generally known and not readily ascertainable. And it's not highlighted on here, but it's also important that a trade secret, its secrecy be maintained. And so when you think about ag data and you think about those categories that I put up on the screen originally, think about whether or not those categories fit into the definition of trade secret. In some instances, I think the answer is absolutely yes. You can absolutely say that some agronomic information, for example, maybe the hybrids or the way that a field is planted and maintained, is a form of trade secret that a farmer wants to keep secret and not share with everyone. But other aspects are not really trade secrets. For example, weather data that a farm might collect and provide to a cloud-based provider doesn't really fit the definition of trade secret. So it's not a perfect fit, but it's really all that we have right now. So when you think about agricultural data and whether or not it's fair to say that the farmer owns this information, I think under current law, the answer is no for patents, probably not for copyrights, no for trademarks, and maybe for some trade secrets for certain types of agricultural data. So the answer to the question, are there laws that protect my ag data, is a little bit different, because here what we want to know is, are there other laws where Congress or states have stepped in and said we want to protect this information that might apply to agricultural data? And there are laws out there that protect data. For example, health data is generally protected by the HIPAA law in the United States, but that doesn't apply to agricultural data. And there are other statutes that apply to financial data, and states have laws that protect personally identifiable information, but none of this really fits perfectly with the types of agricultural data that I mentioned at the beginning of this webcast. So the answer to this question is really no. There really aren't any laws that directly protect a farmer's ag data. So that wraps up our brief seminar on agricultural data ownership. Here are your 3 takeaways for today. First of all, the current laws do not protect agricultural data, except for the law of trade secret, which might protect in some instances. And finally, I would like to point out that the contracts are what really matter here. It really matters what contracts between ag service providers and farmers say, because that's where you're going to really establish your ownership rights with respect to agricultural data. Well, I hope that you liked this 10-minute webcast. If you did, please check out aglaw.us for more information, or email me or find me on Twitter. Thanks a lot.